All right, let's go ahead and get started here since it's 2:01 on the East Coast, so we'll go ahead and get rolling here. My name's Jeff Yeagley with Compass IT Compliance, and I will be the moderator for today's webinar on everyone's favorite topic of GDPR and really kind of outlining some different responsibilities that organizations have under this new regulation. Before we get started, I want to go over a couple of quick housekeeping items. First things first is we've muted everybody's lines to prevent any type of background noise or distractions. However, with that being said, we do want to encourage questions as part of this presentation. So you will see a chat feature, and you can go ahead and either put questions right into that chat feature, or you should also have access to a question and answer tab as well. So you can put them in either spot, and we'll make sure that we get to those at the end of the presentation. Secondly, we're going to make a copy of the presentation available, and I'll be sending that out after the webinar is done later this afternoon. We're also recording the webinar, so that we'll make that available as well through Big Marker, which is the webinar platform, as well as our website and YouTube channel. So I'll be sure to send a link out to that as well once that is done uploading. So I think those are the housekeeping items that we have for today. I'm going to go ahead and introduce today's presenters, plural, as we have two presenters. We have Adam Cravedi, who's our Director of Business Operations from Compass IT Compliance, who will be talking about GDPR, obviously from the information security and technical side. And we also have Joel Goloskie, who is a Senior Counsel with Pannone, Lopes, Devereaux, and O'Gara, a law firm located up in Rhode Island, who will be speaking to the legal aspects of GDPR. So without further ado, I'm going to turn it away to both Adam and Joel to take us through the presentation. Thanks, guys.
Thanks, Jeff.
Thank you, Jeff. Okay, great. So far, we've got about 4 responses on our poll. It looks like 75% of those people have started implementing GDPR. And we've got one person who has done some Googling or reading, which is basically what most people have done. So we wanted to gauge everyone's knowledge so we can determine exactly how much background and detail we need to provide. But it looks like so far the majority of the people responding have definitely started implementing. So please feel free to ask your questions as we go through. That way we can get a sense of where we're at, if we need to pick it up or dumb it down a little bit.
This is Joel. It's actually encouraging to see that the responses are either people have begun or they've been looking at it. We did this presentation a few weeks ago, and a large number of the attendees were kind of learning about it for the first time, which was pretty disconcerting because the deadline was right around the corner. We were kind of hoping we'd get somebody who said that they could be from the EU, response A on this, because we would have turned it over to them. But unfortunately, no such luck. So we'll take it from here.
Great. Thanks, Joel. And we're going to move ahead. Feel free to, if you haven't responded to the poll, feel free to respond. We're going to give a quick really high-level overview of what GDPR is. It's not enough time in a 60-minute webinar to really delve into the full details of what GDPR really entails and who really is impacted. But we will definitely give you the high-level view, 10,000-foot summary. And then we have some ideas around what we see as a good starting point for your approach to implementing your approach to GDPR. That's where we'll end, and we'll hopefully get a bunch of questions in there that we can maybe answer. So without further ado, we'll start with what GDPR is. So your first piece of knowledge is that it stands for General Data Protection Regulation. And if you can say GDPR, you're in good shape. We hear GPDR, GPRD, so we're starting off on the right foot. We know exactly what it stands for.
If you can say that, if you can say pseudonymization, you're ahead of at least 50% of other people.
You're ahead of me too, because I struggle with that word. Joel's got that word down pat. But that's one of the security features or data protection features that is covered in our GDPR. So anyways, GDPR is replacing existing regulations from the EU. So there are some new tenets in here, but the concepts and the ideas are really not new in terms of data privacy from the EU perspective. And they really are adding in the teeth to this 1995 European Data Protection Directive that was missing before. The directive was, very similar in terms of what it covered, but there was no policing, no penalties, no fines, and that's really a major impetus of GDPR, and that's really the reason why we're talking about it today in the United States and probably globally in terms of that. The fines are so huge and so frightening that everybody seems to be talking about it and want to make sure that they're not going to get these fines levied upon them. And we'll talk about the fines in another slide. Basically, all in all, it applies to the processing of personal data. And we use the term here, European data subjects, because there's still a lot of discussion and lack of clarity around whether this applies to residents of a European Union country, including England, even though they're not part of the EU, technically speaking, or residency versus citizenship, and when data is covered and when data isn't. So GDPR refers to them as data subjects, so we're using that term here. We're waiting for clarification around situations and circumstances where this may or may not apply based on where the person is at the time the data is shared, submitted, or processed.
Yeah, and that's a really interesting point that will have implications down the road, because the rule says people in the EU is basically data subjects in the EU, regardless of citizenship, regardless of nationality, and so, or residency. So if you have, say you're a hospital organization, you have people come in from Europe, and we here on the East Coast, Boston, Providence, et cetera, we have plenty of hospitals that are very active in that. The communications you have with individuals while they're in the EU, data you gather from them while they're there is definitely covered. And then there seems to be this sort of black hole. Well, once they're here, do the same regulations apply? And then once they go back home and we follow up, well, they definitely do. And so entities tend to be taking the more conservative approach and saying, if I'm interacting with someone who is in the EU, I'm going to treat all of my interactions with them as covered by this, even when they're here and the plain wording of the regulation seems to indicate that they're not.
Another point to draw out, and I was just on a phone call with another client regarding this question, is where the data resides. And the data, it doesn't matter. GDPR and the regulation, it does not care where the data is stored. It really is more concerned with who the data is about or regarding. So you can be storing data locally in the United States or globally across the globe. And if it's about a European data subject, then it's going to fall under the guise of GDPR. And we're just over the 1 month anniversary. Happy 1 month anniversary to GDPR, because it came into effect May 25th. Who's impacted by GDPR? Well, just about if you just read the guidelines and you just read the requirements, it's any organization that processes information regarding the data subjects in the EU. It doesn't matter whether you charge for this processing or this service. It doesn't matter where you're located as an organization, which we just talked about. And it doesn't matter how you obtain the data. So this regulation applies to all of the organizations within the data stream, within the life cycle of that data. So if you collect the information, you're considered a data collector. If you share that information with third-party service providers, they're considered data processors, right? A data processor does something with the data, manipulates the data in some way, in the hospital, in the healthcare. Okay, hopefully we're back. I apologize for that. For some reason, our microphone cut out. If you can hear me, just type in the chat that you can hear me. Thank you.
Good.
Okay, we're back. I apologize.
Yeah.
The wonders of technology, right?
So we were talking about data controllers and data processors, and the difference between the two, the controllers being the ones who are typically the collectors of the information as well, but not always. And they're the ones that make the determinations of how the data is managed and processed. And then the processor is functionary. But one of the real interesting things that go into kind of an intermediate level analysis of this is when a processor is sufficiently involved in the determination of how the processing will be done, that they become a joint controller. And for those of you who have begun implementation, that might be questions that a set of questions that your organizations would do well to look at this point. The reason I say that is a lot of American entities, of course, are data controllers. They are an internet-based entity, or they're, say, a hotel chain or a finance company that has direct access online right into Europe. Thus, you're a controller. But a lot of American businesses really serve as processors. We're data platforms, we crunch numbers, we provide you with insight and analysis. And that becomes the point where, all right, if I am a controller, I've collected this data, and I've gotten consent to use it to glean insights that might allow me to offer different services to my client base, for example. You may very well offload the processing decisions about how to do that, or even questions about what insights could be gleaned from this data, to an analysis platform here in the US, that platform would typically be thought of as a processor, but to bring it back full circle, if they're too actively involved in the decisions about how this stuff gets processed, they start to meet the definition of controller such that all of the disclosure requirements and access and so on requirements that are imposed on controllers could be imposed on those processors as well. And so that's, if this is sort of your first time to this, or, I've read around about it, that may be a bit more of an intermediate level of analysis, but we see that we have some people on the line who are at that level right now. So we want to address some of those things as well.
Okay. Here are some of the industries that definitely need to be interested or absolutely concerned with GDPR based on the potential client base that they may have. But in reality, it's definitely not limited to these. I mean, we've talked about hospitals already, but you can imagine, airline bookings, hotel reservations, large retailers like Wayfair or Amazon, et cetera, et cetera. So we did mention earlier about the fines, which is definitely, like I said, the scary part. This is not a typo. It is up to 20 million euros, or 4% of your annual revenue, which they call in the GDPR regulation, they call it annual turnover. But it's essentially the same as your annual revenue, and it can be whichever is greater. I don't know if you saw on May 25th, the very first day that GDPR was acted, there were two large lawsuits filed against, one against Google and one against Facebook. They were not for the $20 million euros level, but they were fairly large in terms of the possibilities of the fines. And in most cases, in those cases, both Google and Facebook are going to fight that to tooth and nail with every resource they have, and they have the resources to battle these fines. Whereas the small to medium-sized businesses that we generally see in our industry, or as our client base, we definitely don't have that ability to put that number of resources against it, and so those kind of fines are definitely going to be scary for us. One of the other things is that this is one of the first regulations that give the power to individuals, not just big corporate organizations or groups of users, but an individual has the ability to sue anybody and everybody in the data chain, all holders and processors and collectors of their data, and it's not limited to just one. And an individual can bring that suit to bear all on their own if they felt it was necessary. So that gives a lot of power to the individuals, as well as just as we can imagine with any data breach that may or may not happen, the news of that coming out definitely presents a risk to your reputation.
Yeah, on the enforcement actions, as Adam said, we've seen some private actions happen immediately, the day of, and then in the next couple of weeks. We've not seen anything significant out of any supervisory authorities yet. And so let me walk through how the enforcement of this is structured. And if anyone's on the line who's already well past this, forgive me, but this is enforced by supervisory authorities. There's a supervisory authority at each of the EU member states, and then there are provincial supervisory authorities as well within each of the states. So there's this patchwork quilt that can enforce this. Typically, what is anticipated is smaller breaches, smaller entities, etc., that might be in, let's say, Bavaria, you might see the Bavarian SA go after that. Whereas something that is much more significant with a deep-pocketed adversary, I would expect to see the national supervisory authorities going after. Then it becomes a question of, if it's internet-based, you're very likely to see many, if not all, of the European member states affected. And thus you have the concept of the lead supervisory authority, and they get to get together amongst themselves and decide where is the nexus of this. If it's an entity that has a location in the EU, that would likely be the lead authority. If it's a US-based organization, they would probably look at where is your representative organization, because if you're covered by GDPR, you have to have a representative organization somewhere in the EU. American companies tend to like Ireland, England as well. England says that by 2019 they're going to log into this thing, or something substantially similar. So, but Ireland is strongly connected to the EU, and we're seeing a lot of American companies are using representative organizations there. And so you could expect that to be the enforcement authority, or you could see if there was one nation that had a real significant impact above and beyond the others. We haven't seen supervisory authorities come out and start swinging immediately, in part because it seems to be the consensus that they want to build public confidence through a sort of a strategic approach. Wait till there's another Cambridge Analytica scenario, something that is broadly believed to be egregious, and then step up to that rather than just go out and hammer somebody and give the appearance of being the aggressor. Where I think American companies are much more vulnerable are the private actors. And there's two types that I just want to take a moment to talk about. One is the NGOs, the private. This thing gives private causes of action to not-for-profit organizations to speak on behalf of affected individuals. And there are some that are already quite active. The most famous one is NYOB. That's I have that backwards. It's NOYB, none of your business. They're out of Austria. Their leader, Max Schrems, successfully sued Facebook a couple of years ago. They've already filed suit in 4 different countries against Facebook, Google, WhatsApp, and Instagram. Then OCU is like Organization of Consumers United or something like that. They're in Spain. They're suing Facebook related to Cambridge Analytica, and they've said on their website that they are equivalent organizations in like Portugal and Belgium and a couple of other countries plan to do the same in the next couple of weeks. Again, is an NGO going to jump out and target some small or mid-sized American company because, it didn't quite have its notices of privacy practice up and running correctly, by end of July? Probably not. Where companies that make up our client base really have exposure is in the category that we're just calling trolls. Sort of like the black hat hackers. These are people that are out either to cause mayhem or to generate personal profit. And here's how this could work. I troll around to websites that are covered by the EU. I find that there are some that have not updated their privacy notices don't have the proper opt-out, don't have the proper opt-in, et cetera, et cetera. Maybe I even send a letter requesting, trying to implicate my right to be forgotten, and I don't get a response. And I'm in some former Soviet bloc country that's now a member of the EU. I'm in Moldova. And I go into a court in Moldova and I get a judgment on this. And then under international law, I work with a law firm in New York, Boston, wherever, and I get that judgment enforced. I work with a law firm that is in the jurisdiction of that American company. And the lawsuit drops and I get a letter from them saying, hey, you know what, for $50,000, we'll make this all go away. But at that point, they probably don't even have to, because the judgment was perfected. And under international law, if you get successfully sued in the US, you can show up in Europe and enforce that, and the opposite is true. So that's what we see being the unintended consequence of this, is people using this mechanism, this private right of action, to profit off of sort of small and mid-sized firms that haven't gotten ahead of the game on this. And it's a good business model. It's a shameful one, but it's a good one. So we expect it to be used. Well, that was cheery, wasn't it? We'll move on to some recommendations.
Joel is very doom and gloom at times, but we haven't seen any of that action right now. And I think there are plenty of other targets available before we start seeing something like that. And I think there's a lot of wait and see for precedents to be set before we start seeing some of that. There is definitely some wiggle room in the regulation for abuse, and honestly, being an idealist, which I really am not, but being an idealist, I would hope that that wouldn't happen, but it definitely is. It's definitely a possibility. So a lot of you who responded to the poll, and thank you for responding, said you've started implementing. So maybe you've taken a different approach, or we definitely interested to hear a little bit about your approach. But the next 4 slides are what we've come up with in terms of where we think the path lies in terms of how do we approach GDPR and implement something that will cover us in terms of if any of these lawsuits or questions come about in terms of data breaches. Excuse me, I'm sorry. So our first recommendation starts with data identification. Right? And these recommendations are not really anything unique or new because of GDPR. These are definitely tried and true, well-known controls and approaches to any form of data privacy, whether it be healthcare and HIPAA and HITRUST, or PCI and payment card data, or personally identifiable data, or even intellectual property data, all of which are covered by GDPR as well, but these can apply in any case. The first one being data identification. You have to know where your data is, what data is being collected, where you're storing that data, and who you're sharing that data with. All of these are requirements right from GDPR, and you have to share this information on your disclosures when you present a disclosure and opt-in form for consent to collect data. So the first step here is identifying that data. You also need a business and legal justification for collecting the data, and you really should only collect data that you need to process or perform the service that you're offering. We also have down here unstructured data, which is probably the bigger challenge. most people collect data for part of an application or some service that they're offering, and that's pretty clear and well defined in terms of what data you need, where it's stored, how you go about collecting it. But unstructured data includes things like email, and by the strictest of definitions in GDPR, personal information is identified or defined as simply a first and last name, along with any other identifying information that can relate to that person. But a name, an email address, an IP address, all of that information is collected and stored in multiple different locations, and trying to get a handle on that data can be a huge challenge. And also we're waiting for some more clarification around things such as email, because just by using the term email, I mean, that scares a lot of people, because anybody who has a signature in their email is sharing some personal information with you. And is that really going to be held subject to GDPR regulations? And what do I do about that based on based on an understanding of how email works and how email is transmitted across the network? There's a lot of places where that's not controllable, but it is something to consider, and it is a good idea to identify that data, even if really it comes to the point where it may or may not be held, you may or may not be held accountable for that data.
One of the things while we're there, I just want to stay on this slide for two points. As to the unstructured data, recital number 30 to GDPR, there's a whole bunch of recitals that go along with it. And they specifically talk about online identifiers provided by their devices, applications, tools, and protocols, such as IP protocol addresses, cookie identifiers, and other identifiers such as radio frequency identification tags. So even if you're not getting information about this is a person named Hans Jorgensen, you can identify this person as IP address X, and IP address X likes the following, and tracking that sort of thing is covered by GDPR. So you don't have to get into the sort of old-fashioned identifiers like name and address and whatever to still be covered by this. And then under identification, that last, what data is truly needed, and then is data collected that is not needed. One of the differences between GDPR and say HIPAA, more the American view of this, is GDPR is very explicit that when you collect data, you have to tell people for how long you're going to keep it. Now, that doesn't mean you have to tell them, on a Tuesday in May, 3 years from now, but you can put it into descriptive terms. Like in healthcare, you might say for as long as required by law. In, say, you're a hotel chain, and this is the person's part of your membership program. For as long as you are a member of our rewards program, we shall, etc. This really bumps into one of the primary business models of data, which is creating data pools, and the value of data pools being the insights that you can glean from them over time as they grow. And you can create and maintain anonymized data pools under this regulation, but you can't keep identifying information for longer than the purposes you've identified, or you're in violation. And that's going to change some people's businesses models to a degree or more.
Yeah, we didn't talk about retention periods, but it is one of the other requirements in GDPR that you must clearly define your retention period and you must adhere to your retention period. Otherwise, the data that you store is going to be always subjected to GDPR. Actually, we may mention them here, and we do. Recommendation number 2 is make sure that your disclosures and consent are clear and easy to understand, right? They must be current. They must cover in detail the data that's collected that we talked about on the last slide, and that you have a definite retention period, or I should say a defined retention period for the data that you're storing. And if you're sharing that data with anybody, any third-party processors, you have to at least identify that you're sharing it for a purpose. In our last presentation, we had a conversation around what does that mean? Do we have to specify the organization that we're sharing it with? And what if we're sharing it with multiple organizations because we have a group of people who do the same processing for us? Or what happens when that organization, we switch that organization? And
the answer to that is right there in Article 13. It's the recipients or categories of recipients of the personal data, if any. And so you would probably not want to specifically list a processor. Now, there are scenarios where you might, but typically you probably wouldn't, because you want the ability to change processors or to add them or whatever. So you're talking about categories of recipients. So you may say, we may share this with a cloud-based data management service of our choosing, that kind of thing. When you're describing this, you're going to always want to walk that line, and it's never a clear line, between being specific enough so that when the person reads it, they understand vaguely what you're talking about. It's not just all legalese, but it's not so specific that it's, a guy named Bob in the information department at, company X. You want to be sure to give yourself that flexibility.
And the last point on this slide is that customers have to have a clear and obvious opt-in option. Now, it cannot be defaultly selected, right? So the opt-in has to be something that they either click on to activate, or they select an option out of opt-in, opt-out, but it can't be pre-filled. So the data subject must opt in physically in air quotes, by clicking a mouse on a radio button or a check mark, or selecting a link that says opt-in, and that brings them to a more defined disclosure or whatever. But you must have that consent. You must track that consent and be able to show that the data subject did consent to this data sheet, to providing data.
Yeah, exactly. 2 things on that one. The opt-in was part of a trend that we saw over the last year or so. Originally, the level of denial was, this doesn't really apply to us over here, right? How can they enforce this? Well, it went from this doesn't really apply because it's a European reg to, okay, it applies, but how can they really enforce this? And then one that we saw is the opt-in thing. Well, opt-in, it doesn't really mean opt-in, right? Like my customer list, like all the people that, I collect data from right now, you're telling me I have to then send them an email and ask them to opt in? Well, yeah, that's what you have to do. So particularly retailers, newspapers, etc., you can expect to lose some of your database because people just won't opt in. They either sheer laziness, they're overload of just email fatigue, or they view it as an opportunity to kind of downsize their online bombardment. The second thing about this opt-in is you can't have forced consent. Okay? And the way you see that is bundling a service, bundling something they want with consent to use your data, for these other purposes. That's specifically prohibited. And so, to use the Facebook thing, we're collecting your data to share with your friends and to do X, Y, and Z. We also want to give it to Cambridge Analytica to consent to being part of our platform. You have to consent to the full use, and that will be something that we anticipate the supervisory authorities will get involved with, that sort of forced consent and bundling issue.
This one here talks about data transparency and oversight. Again, it ties into what Joel was just talking about in terms of use for data, data storage, where you're sharing that data, who you're sharing that data with, and being able to provide some, and it also accounts for some of the data subjects' rights in terms of their rights to the data. So they have, we did allude to the right to be forgotten, which is the right to request your data be removed from the database. Now, if I do that as a data subject and I ask for you to remove my data, that means I'm severing the relationship, right? So we have this conversation early on in GDPR, internally in Compass, and the question was asked, can I be a member of a rewards program and then ask them to remove my data and still be a member of the rewards program? Well, no, it doesn't work that way, right? So if you ask to be forgotten, then you're severing that relationship with the organization, and that makes sense. You also have the right to request the data to be in a format that you can share it with another party. You also have the right to ask for that data to be corrected if you notice that it's incorrect. And they talk about responding to these requests from the data subject in a reasonable time frame, right? And that's what the regulation says. It doesn't really say what that is, but the understanding here is that, or the implied understanding is within 30 days. So you have to have what's called the subject access request form, or a SARS form, that a data subject can use to make these requests, and that you're collecting and you're responding to in a timely manner. And then the final recommendation we have here goes to vendor management or third-party management or vendor due diligence for anybody in the financial sector who is well aware of the requirements for vendor management, because they've been required to have a due diligence program for at least 5 years, if not more. But basically, it's just managing your vendors. The people you share data with, you want to make sure that they also have the ability to comply with GDPR requirements. And very specifically, the GDPR requirement says that you must use certified GDPR third-party agents, but there's really no such thing. The requirement doesn't allow for any sort of GDPR certification. So they're really either leaving themselves open to adding a certification body at some point in the future, or also looking for people who are preying on people who want to be GDPR compliant. And really, that's what they should have said: GDPR compliant third parties, where they've gone through some sort of assessment, or they can show a plan in place for addressing GDPR requirements. But there is technically no certification today. If anybody comes to you and say we can certify you in GDPR, they're lying to you, because there's no way, there's no certification outlined in the framework. So this just talks about how to put everything, how to manage your vendors, and just do your due diligence on making sure that they're securing the data, and that they can respond to these requests, especially the request to be forgotten if you're sharing data, within that time frame, which is 30 days from when you receive the request. So it must be, if they're asking to be forgotten, it must be erased from all databases within the data chain. Anything on that, Joel?
No.
Okay, so that leaves us with at least 15 minutes for questions. I didn't see anybody send any questions in at the time, but we're definitely interested in hearing what questions you may have around GDPR, even if it's on something that we didn't necessarily bring up in this presentation. And if you don't have any questions at this point, we're also open to answering your questions after the fact. So feel free to send those in. At this time, does anybody have any questions they'd like to bring up? Please feel free to type them in the chat or Q&A section. I see a question. So Mike asks, what recommendations do you have for hashing IPs or storing the hash? So this hashing the IP kind of fits into the framework of, I'm going to try the word, pseudo-anonymization. I was pretty close, not perfect, of data, which is allowed in GDPR. Basically, pseudo-anonymizing data is modifying the data in a format that makes the data unrecognizable or unreadable and not related to the individual. So I think that in terms of hashing the IPs, that definitely would be a good idea in terms of how to protect that data. Storing the hash value, absolutely, you can definitely store that. And then the key to pseudo-anonymization is that you can store that pseudo-anonymized data for as long as you want because there's no direct relationship back to the individual. So that would be my advice. Joel, did you have anything to add to that?
Yeah.
And then we have a second question.
Yeah. Well, so two terms that you'll hear, these will become part of your lexicon: pseudonymization and anonymization. Anonymization is the easy one to describe. It is data that's been so sufficiently stripped of identifiers that you can't add it to other information and backfill in to figure out who someone is. Pseudonymization means on the face of what you give me access to, I can't tell who this is, but if I combine this with some other data, I can. Right? So one of the ways that you do that, of course, is through having a key. Right? And that key can be the thing that identifies the person for that data. It can also be used to identify them from other data. So you may have a larger pool. So you may have that IP, right? And you may store that hash. You may store it using an identifier that also relates to more specific information that you keep about the individual who has that IP address. That re-identification key, that's the protected piece. And so that you can't keep forever. When you don't need that anymore, you have to delete that. But without that, the information that you can't identify with, that's anonymized, and you can keep that forever.
So there's no key when it comes to hashing. It's a one-way function, so you're safe with the hash. We have a question from Kevin and then a question from Mark. So Kevin says, are there templates for data processing agreements?
You know, the thing on that is the processing would be, like, I have various clients that process data for other entities, and what they're doing is sometimes so fundamentally different that agreement A really doesn't look like agreement B. However, you're going to find commonalities. In healthcare, for example, there's always a business associate agreement, a HIPAA business associate agreement, those things always look a little different, but HIPAA requires certain things and they have to be in every single one. Same thing here. You're going to find provisions, and over time, just as happened with HIPAA, there will be language that the community sort of determines that they like, and people start copying and using, and that will be sort of the standard GDPR language that evolves, but that takes some time to develop.
Okay, and Mark's question talks about our representatives in the EU. And he wanted to know if we could say anything more about our representatives in the EU. For example, the representatives we need to have in the EU, I think you mentioned that Ireland was a preferred location. Yeah, because the big thing about you picking a representative in Ireland would be that you can understand what they're talking about to some degree, depending on their accent, right?
Yeah.
But they speak some form of English, unless your organization is fluent in Spanish or Portuguese or Moldovan,
Yeah.
right?
So the representative organization will likely be a law firm. There are law firms that are jumping into the business of being representatives for US-based companies. Now, if your gig is such that you really deal with Spain, you focus all your time in Spain, then by all means get one there, because if something goes sideways, you're probably going to be dealing with the Spanish supervisory authority, or you're going to get sued in Spanish court. So I would recommend having, in that case, a representative where the majority of your business is. But if on the other hand, you're like someone that came to us a little while ago and they do websites, marketing websites for major American tourist destinations, well, they're pretty much all through Europe. There isn't a focus. It sort of comes, it boils down a little bit to the economics. The more wealthy countries travel more than the others, but there I would, I'm quarter Irish, so perhaps I'm showing my bias, but yeah, Ireland is good for the reason Adam said. They speak English.
Mike asked a follow-up, but if you exchange data with a hash plus a salt, is that pseudo-anonymous enough to still be compliant? Would we need third-party intermediary? And actually, Mike, you don't need to pseudo-anonymize the data to share it, but you need to secure it. So if you have the need to hash and salt, then by all means, hash it with a salt. But as long as you're encrypting the data during transmission and encrypting the data during storage, that's sufficient enough to be compliant. What we're talking about when we get into the anonymization and pseudo-anonymization is storing data after that relationship has ended for a long-term period of time. So you don't necessarily have to do anything different today. Using TLS will, during transmission, if you're sharing over a website or web transmission, would be sufficient. If you're using a secure FTP type of transmission, that would be sufficient. So any form of protecting the data that you would take for any other form of data still fits within the GDPR requirement. Mark asks another question. If we are a privacy officer, how might I protect myself from personal responsibility? This is definitely for you, Joel.
The personal responsibility is not legal, fortunately, unless, if you ran out and, got half in the bag and started showing people's personal data, then I don't know, perhaps you could find yourself the subject of a suit. But generally speaking, it's your organization. You're acting as an agent. Even if you're acting negligently, you're acting as an agent within the scope. So your exposure here is not so much that you're going to be a named defendant in some lawsuit, or the Belgian supervisory authority is going to name you. It's more that when things go sour for your company, even, if you've been lucky to get GDPR on the radar screen at all, but that gets forgotten. All that they remember is like, hey, we just
I think we're back. Sorry about that. Again, wonders of technology. And then Joel was just saying that he hasn't seen anything regarding personal liability inside of GDPR. And then we did have one other question, and I apologize. I am going to mutilate this name, but it looks like Mutiab, but I apologize for killing that. Does GDPR cover companies that collect personal information on paper or non-digital? And the answer to that question is no, it does not apply to non-digital formats of information. It only applies to information in a digital format.
I'll read you right from Article 2. It says this regulation applies to the processing of personal data wholly or partly by automated means, and to the processing other than by automated means of personal data which form part of a filing system or are also intended to form part of a filing system. This thing has been largely focused on electronic data. I wouldn't want to be the test case for, we don't really need to secure our paper, because the language is broad enough that it's probably not going to be one of the first issues that gets litigated, but I wouldn't want that kind of exposure.
Well, not to mention the fact that there are plenty of other regulations around the protection of personal information, private information that do cover paper. PCI, HIPAA, PII laws in each individual state all apply to paper records in addition to electronic records, and GDPR doesn't supersede any of those in terms of its jurisdiction. So it doesn't mean it's free for all on paper, as Joel said. You must protect it regardless, and maybe if it's not covered under GDPR, it's covered under another regulation that you should be following, another rule, guideline, law that you should be following anyways. We are just about out of time, so I will again apologize for the brief audio issues that we had during the presentation. I thank everybody for the questions that they had and for taking the time this afternoon to join us on our webinar. As Jeff said, there will be a follow-up to this handout. The presentation, the webinar was recorded. It will be made available to anybody who would like it, who wasn't able to attend, although I know you can't hear me because you weren't here. And if you have any additional questions, please do not hesitate to reach out to us here at Compass. We'd be happy to answer questions in more detail if we didn't cover something that you are interested in hearing. So thank you all very much for your time this afternoon. This does end the presentation.
Thank you, Nat.
Thanks, everybody.